on Senate Bill 667 will be first up for public hearing.
Thank you, Mr. Chairman and committee members. For the record, Mike Henderson, State Senator from the 3rd Senatorial District, here to present Senate Bill 667 on workers' compensation and administrative law judges. Currently, the Administrative Law Judge Review Committee is required to take a retention vote and conduct performance audits periodically of each administrative law judge. The current process takes too long and does not effectively remove one for misconduct. The new section in this bill allows the Division Director of Workers' Compensation to file a complaint with the Administrative Hearing Committee against an administrative law judge if the AHC determines the complaint is valid. The director may impose disciplinary steps, including termination, and the grounds for discipline include. And it's kind of funny, you'll see this list in a lot of different things here, but it's if committed a criminal offense, convicted or entered a plea of guilty to a criminal prosecution, habitually intoxicated, willful neglect of duty, corruption in office, incompetency, or moral turpitude, or oppression in office. So you kind of see those 7 deadly sins. You see in a lot of things with it there. If there is no finding for disciplinary action, the administrative law judge will then resume duties. Also in this bill, there's a section that involves payment and retirement benefits. The language provides that pay for an administrative law judge or the chief administrative law judges shall be determined by the rate outlined in the law and will not increase in rate when the executive branch employees increase. And it removes the reference to the chief legal counsel. Finally, it protects the retirement benefits of someone who is removed. It makes sure that they maintain their retirement benefits they've accumulated up to that point. I think there's some people behind me that can probably testify in more depth if you have any questions, but I'd be happy to answer any questions I can.
Thank you, Senator. This is, I believe, the same exact bill that I've had that we almost got to the finish line last year. But as we know, in the Senate last year, the dynamic was a little bit different, and it fizzled out at the last couple days. Any questions from the committee? Seeing none. First witness in support of Senate Bill 667, please come forward.
Thank you, Mr. Chair. Stephen Marion, Legislative Liaison for the Department of Labor. We appreciate you taking the time to hear this bill. I want to thank Senator Henderson for his work in carrying this bill this year. This bill's taken a few different forms over the years, and we're confident this version achieves our desired goal and satisfies all parties involved as well. The current oversight process we have for ensuring the performances of ALJs is outdated and frankly dysfunctional, and this bill does a great job of allowing for a much more streamlined process for making sure that workers' compensation cases are adjudicated at the highest level. Our ultimate goal at the department, and everyone's goal, should be to ensure that every case that is brought before a judge has an equitable chance of getting the due process that is guaranteed in law. Currently, oversight of ALJs in the Division of Workers' Compensation has no practical mechanism for removal. The ALJ Review Committee conducts performance audits every 2 years, where they give a recommendation of confidence or no confidence. It takes 3 or more votes of no confidence under 2 successive performance audits by the committee for an ALJ to have their appointment withdrawn. There are also votes of retention, and these that state if an ALJ receives 2 or more votes of no confidence, they can be removed. The problem here is that these votes of retention only happen once every 12 years. So take, for example, an ALJ who is not fulfilling their duties or are incapable of doing their duties for any of the reasons outlined in Senate Bill 667. There's no timely process to react to these situations. This legislation is needed so that workers' compensation cases can be handled in the highest quality, and if they aren't being handled in that way, due to any of the reasons listed in the bill, the Administrative Hearing Commission, a neutral third party, can handle that matter. And with that, I can take any questions.
Are there any questions? Seeing none. Thank you for your testimony today. Moving to the next in support of Senate Bill 667.
Chair Schroer, members of the committee, my name is Luke Reed. I'm here on behalf of the Missouri Chamber of Commerce and Industry, here to support Senate Bill 667. We believe that it injects fairness and accountability into the ALJ process, and we support the provisions 287-610 and 621-045.
Perfect. Nice and concise. Any questions? Seeing none.
Thank you.
Next in support, Senate Bill 667. Please come forward.
Good morning. Matthew Smith with Associated Industries in Missouri. Just want to go on record of support of this bill. We should ensure that ALJs have the right oversight and accountability, especially how important they are to workman compensation and streamlining that process. So with that, I'd be happy to answer your questions.
Any questions? Seeing none.
Thank you.
Next in support? Seeing none. Next in opposition of Senate Bill 667? Seeing none. Any for informational purposes? Seeing none. Senator, closing remarks?
Thank you.
That will wrap up the public hearing on Senate Bill 667. Now moving to Senate Bill 354 from Senator Black.
Good morning, Mr. Chair and members of the committee. For the record, my name is Rusty Black, and I represent the 12th Senate District. Senate Bill 354 is a measure designed to strengthen Missouri laws surrounding the misuse of inhalants and chemical substances for recreational intoxication. This legislation addresses growing concerns related to the abuse of volatile substances, which are referred to as huffing. Huffing possesses serious health risk and public safety risk, especially among young people. Senate Bill 354 updates and clarifies and expands the list of regulated substances to include additional chemical compounds and expands the list of regulated substances to include additional chemical compounds, diafluoroethane, triafluoroethane, and other nitrate-based compounds. The bill prohibits the intentional inhaling of these substances for the purpose of inducing intoxication or altering mental or sensory states, and extends those restrictions to individuals who knowingly possess or purchase such substances with the intent to facilitate such abuse. First violation would be a Class D misdemeanor with the potential for diversion to a drug treatment program. Second offense would be elevated to Class A. Any subsequent violation, Class D felony. This graduated approach offers a path of treatment and rehabilitation for first offenders. I think for sure you, Mr. Chair, you've heard this when we were in the House, right? And I don't know if you remember, somewhat what put me on this path was an attorney at home, and then my oldest granddaughter's ad litem was killed in Chillicothe in a 25-mile-an-hour zone when she was hit by somebody doing 85 that also had their child in the car. And then the other part, Mr. Chairman, that you've had listened to before, we remember my teaching ag, keeping air dusters, I kept it in the gun safe, and we would mark the can that we were using because there was such controls supposed to be on that at school. You know, the expectation was we didn't allow kids to grab that and go out in the shop and huff, and then to find out that truly these substances are not illegal in code, even though we know they do harm. I'm, of course, not wanting to just add tremendously jail population, but as you know, you and I have worked on substance abuse. Well, why not? Let's get this added, and let's try to point those people that we find with these substances to get some help. Thank you, Mr. Chair. I'd answer any questions.
Before we head into questions on Senate Bill 354, Mr. Secretary, please call the roll.
Senators Schroer.
Here.
Gregory 15. Brown 26. Here. Berger. Here. May. Here. Roberts. Schnelting.
We have a quorum, and just so the committee knows, we do have some substitutes on some of the House bills from last week. We're going to go into an executive session next week on those. We're going to distribute that to you electronically so you have time to look it over. But moving back into the public hearing on Senate Bill 354, are there any questions for Senator Black? Seeing none. First witness in support of Senate Bill 354.
Good morning. I'm Timothy Faber. Don't have a lot to say, just I support the bill.
Any questions? Seeing none. Next in support? Seeing none. Any in opposition? Seeing none. Any for informational purposes? Seeing none, Senator, that will conclude unless you have any closing remarks. Moving to Senate Bill 805 from Senator Nurrenbern.
Good morning, Mr. Chairman and members of the committee. For the record, I am Maggie Nurrenbern, serving the great people of Senate 17 in Clay County. Senate Bill 805 modifies the factor a court shall consider when awarding custody to parents. Custody factors, essentially those, they're the same as they were written nearly 50 years ago. The equal parenting time presumption was passed by the General Assembly 2 years ago, and the updates to the custody factors are needed to help the court in determining best interests under equal parenting. Changes to these factors include the following: whether the parents live too far away from each other to be able to move the child back and forth during school days, whether the child has educational, medical, developmental, psychological needs, such as special needs children or children with significant physical disabilities or medical needs, where changes in environment or moving back and forth between houses may not be in their best interest, whether a parent has a mental health issue or alcohol or drug abuse that could jeopardize the safety of the child, whether there are domestic violence issues that affect the child's safety or developmental needs, whether parents have demonstrated a willingness to cooperate to reduce the amount of conflict to which they expose their children. Similar to domestic violence, this can have a long-lasting impact. Effects on development, the well-being of the child should always be front and center in these decisions. This bill also addresses the confusing language requiring the court to hear the unobstructed input of a child to the child's custodial arrangement. This provision, as currently written, does not define unobstructed input. It also does not allow the court to consider the age or the maturity of the child. As a result, this provision could be interpreted to require courts to hear from very young, even preschool children who do not understand the full impact of the custodial arrangement. Further, it has actually encouraged parents to bring children of all ages to court to testify. This is something that courts have in the past been very cautious of in an effort to protect children from being in the middle of interparental conflict. Similar language was passed out of the Senate 2 years ago with tremendous bipartisan support. So I'm hoping we can continue this conversation to do what is best in the interest of children. Thanks for hearing this bill this morning, and I know we have some witnesses behind me that know a lot more about this than I do, but I'm happy to answer any questions at this time.
Any questions for the senator? Seeing none. First witness in support, Senate Bill 805, please come forward. And for all witnesses, make sure you have a witness form that's filled out and just leave it on the desk.
I will. Thank you. Mr. Chairman, members of the committee, I am retired Judge Margaret Donnelly. I served on the bench in St. Louis County for 10 years until last year, after a 20-year practice specializing in family and juvenile law. I was assigned to family court during my entire time on the bench, including serving for 2 years as the administrative judge of the family court. And I thank you for allowing me the opportunity to testify in support of Senate Bill 805. From my years in practice and on the bench, I learned it's critical that our statutes provide clear direction, not only to attorneys and judges, but also families. The factors required to be considered in contested trials in family court, as Senator Nurrenbern has pointed out, haven't been updated in decades. Much has changed in our statutes, including the provision of the presumption of equal parenting time, and it would be beneficial to have the factors modified as well. The changes in Senate Bill 805 are not creating new factors, but they are adding information for the court's deliberation in determining custody. They present the court, I think, with a deeper and broader understanding of each individual case. And the changes provide more specificity as to what evidence will be considered by the court and how the circumstances of each family will impact how the custody plan is developed. This is very helpful to attorneys as they counsel their clients, and they give the families a better understanding of how a case will be decided. I will also give my support to modifying factor number 9 specifically. That modification of this factor in statute 2 years ago was so that the viewpoint of the child could be taken into account. However, as Senator Nurrenbern has said, it's very confusing. It requires unobstructed input with no definition of what that means. I believe the language in Senate Bill 805 provides a structure for how the court will learn about the child's wishes, but protects young children from pressure that they must favor one parent over the other. Once again, I appreciate being able to share my thoughts on this important legislation, and I would be happy to answer any questions. Thank you.
Thank you, Judge, and thank you for your service in such a difficult area of the law. I practiced in family law for several years, and I'm not going to do it again.
I actually think you were in front of me one time.
I think so.
Remember, yeah.
I think so.
Yes, thank you.
Any questions? Senator Brown.
So in subsection 9 that you mentioned, it says the reasonable input of a child as to the child's custodian. If the court deems the child to be of sufficient ability, age, and maturity to express an independent, reliable preference, how do you think that would be interpreted? As far as that, still seems a little bit vague. So how would you see those different factors being balanced in determining whether it was appropriate to bring a child in to testify in a case like this or not?
I think that the court would, often in these cases, there's a guardian ad litem, but also would just ask questions about, is this a child, again, maybe has special needs? Has the child been in any sort of counseling because of pressure they're feeling from the parents? It really, you do have to individualize it with each case, but we're used to doing that under actually the prior way in which we've always had a factor that says, if appropriate, you are to allow a child to speak directly to the court, or you to get their input through the guardian ad litem or some other way. We've always had that. It just was changed with this new language 2 years ago, and I found as a judge, and I think most practitioners, we just really didn't know what unobstructed input was. And so this is a little, the version in Senate Bill 805, in my opinion, goes back to where it was before 2 years, with more fleshing out what you are to consider as far as when a child should come and directly talk to the court, and in what other ways you might be able to get the input.
Okay, thank you.
Good. Thank you.
Any other questions? Seeing none. Thank you, Judge.
Thank you again.
Next, in support of Senate Bill 805.
Good morning. My name is Laura Underwood, and I am a family and juvenile law practitioner for almost 20 years here in Cole County. This piece of legislation updating the factors has been something that several family law attorneys and stakeholders from around the state regarding judges, guardian ad litems, parents' attorneys, some grandparents' attorneys, juvenile attorneys, mom's attorneys, dad's attorneys. We've kind of gotten everyone together over the last couple years and developed this language and this legislation. The last year, it got very close to passing. There were some changes made in the Senate that never got through the House, but overall, in the 3 years we've been presenting this has been a bipartisan, bicameral bill to update the factors. It doesn't swing really one way or the other. It's just trying to catch the law up to what families are doing. As Senator Nurrenberg and Judge Donnelly commented, the factors have been around since the 70s, and families have changed a lot since the 70s, but our laws have not kept up with the reality of how people parent, whether it's in a divorce or whether the parents have never been married. This is just trying to bring that up, and we're hoping this year we don't run out of time. That was really what happened last year, is we ran out of time, and so we're hoping that we can get this taken care of so that our judges have a little more guidance, our attorneys can advise our parents better as to what to do, and our children overall have better outcomes because they have the ability to spend as much time as possible with two appropriate parents. I'll take any questions if you have any.
Are there any questions? Seeing none. Thank you again for your testimony.
Thank you.
Moving to those in support. Any others in support? God bless you.
Thank you, Mr. Chairman, members of the committee. Tricia Workman here today on behalf of the Missouri Coalition Against Domestic and Sexual Violence, and there's not much I can add to the two witnesses. Just appreciate the senator's work on this and look forward to working with the committee to get this done.
Thank you for your testimony. Any questions? Any further in support? Please come forward.
Good morning. I'm Timothy Faber again. Ideally, we would live in a society that does not have divorce and broken families. Unfortunately, that's not the case. And as long as we are dealing with families that are being torn apart, I think this legislation is good because while it does not instruct a court on what to decide, it does instruct them on factors to consider that might otherwise be overlooked. And so I think this is a good bill, and hopefully it will help our children in Missouri. Thank you.
Any questions? Seeing none. Any further in support? Please come forward. Any in support of Senate Bill 805? Seeing none. Any in opposition? Seeing none. Any for informational purposes? Any closing remarks?
Thank you. I appreciate your time this morning.
That'll conclude the public hearing on Senate Bill 805. Moving to Senate Bill 453 from Senator Trent. And then we will move to Representative Lewis thereafter. I think there he is.
Thank you, Mr. Chairman, members of the committee. Curtis Trent, representing Senate District 20. Senate Bill 453 would require or would prevent any possibility of parole or early release for individuals who are convicted of the crime of tampering with the judiciary. So a little background on this. The Judicial Conference, from which came the Judicial Privacy Act in 2023, also reviewed criminal offenses related to the administration of justice and noted that there was a lack of similarity between tampering a judicial officer and tampering with a judicial proceeding and tampering with a witness or victim of a crime. And so this would attempt to align those this penalty for those three offenses, which are very similar in their nature and their impact on the justice system. We'll be happy to answer any questions.
Any questions? Seeing none. First in support.
Mr. Chair, members of the committee, Eric Jennings, Government Relations Counsel of the Supreme Court on behalf of the Judicial Conference of Missouri. I want to thank Senator Trent for once again coming up to bat in addition to his previous work on the Judicial Privacy Act in 2023. As the Senator mentioned, when we were continuing to review items as part of enacting the Judicial Privacy Act, we had looked at some of the tampering offenses. As he mentioned, tampering with a witness currently includes this prohibition on parole being a possibility, but tampering with a judicial proceeding or a judicial officer does not. So we had simply asked if he might be willing to introduce this to have a discussion about aligning those three statutes a little bit more than they are now. I know that Senator Trent had intended to distribute to the committee a copy of a committee sub. There is a companion bill in the House, House Bill 1457, that Representative Hinman had filed that includes the tampering offenses, but also includes some updates, some fine-tuning on the Judicial Privacy Act itself. One of the items that Representative Hinman was interested in was adding clerks to the list of covered officers in that. And I believe there was a request made of him to include juvenile officers and chief deputy juvenile officers as well. So as he was filing that, he'd also agreed to include these tampering offenses to mirror Senate Bill 453. and include a few items to fine-tune the Judicial Privacy Act. And so I wanted to mention that, let you know if you have any questions when you're reading through that proposed committee sub, that I'd be glad to answer those for you.
Any questions? Senator, please proceed.
Thank you. Yeah, it was just within the last couple of years, right, that we passed the Judicial Privacy Act? What year was that?
2023.
Got you. So this, for lack of a better word, kind of enhancement that folks can't be eligible for parole, probation, or a conditional release. I mean, it's only been 2 years. Why do we need to add this to it?
We have already had folks convicted under that tampering with the judicial officer in some of the same situations that originally prompted what we requested with the Judicial Privacy Act. And so this was not something that came to the forefront in 2023, but has in the intervening years. We've had a couple of cases with that, situations where the severity of the conduct and the amount of time before those individuals will be released is probably not lined up properly.
All right. So you're finding that folks are then, I guess, getting out, they're getting parole, they're getting probation or conditional release, and then reoffending?
Or would be eligible for that, probably, rather than reoffending just yet.
Okay, because, yeah, I mean, with it only being 2 years,
right.
I'm
But
just
the
trying to get more
circumstances of the
information.
underlying crime that they were charged and convicted under, and the concerns about judicial safety, those have only grown since 2023. We were probably, I wouldn't say at the forefront, but towards the front of the pack in terms of passing legislation. Multiple states have done that. We have had additional instances here in Missouri, some that have made the press, some that have not. So the underlying, the reasons underlying the Judicial Privacy Act are still present, very much so.
Thank you.
Thank you.
Senator May.
So what is the maximum sentence for this, for violating the
It's going to
tampering
depend on the conduct and the, whether it is first or second offense, and I'd be glad to get the penalty range for that
Right,
for you.
because is it 20, 25?
I will have to look
Okay.
on that.
Can you get that information to me,
Absolutely.
please? Thank you.
Any further questions? Seeing none. Thank you for your testimony. Moving to those in support of Senate Bill 453. Any further in support? Seeing none. Any in opposition? Seeing none. Any for informational purposes? Seeing none. Any closing remarks?
Thank you, Mr. Chairman. Appreciate your time and the committee's consideration.
That will conclude the public hearing on Senate Bill 453. Moving to House Committee Sub for House Bill 1464. Representative Lewis.
Thank you, Chairman Schroer and committee members. Thank you for hearing this bill. I am Representative Ed Lewis. I represent District 6, Randolph and Macon counties. This bill was voted out of the Children and Families Committee as House Bill 219 with no votes, voted out of as House Bill 1464 from legislative review, again with no votes, and cleared administrative rules twice with no votes. So it does have broad support on our side. Came across the floor 144 to 4 votes. So has broad support. This bill has its origins from a council that was created by statute in 2021, and I chaired it for 18 months. That council ended in December 2023. It was the statewide council against minor sex trafficking. Many of the provisions of this bill come from that council's report. That council's report detailed in fact, every item that was in the council's recommendations for things that we need to do to prevent minor sex trafficking on page 18 and 19 of this report that was issued to Governor Parson and to the general legislature are incorporated into this. This bill is 69 pages, and it seems like that's a lot. One of the reasons for that is one part that makes this bill longer than it really is we changed the words from child pornography to child sexual abuse material. The word pornography implies consent, and a child cannot consent to making inappropriate sexual material. And since that occurs 58 times in statute, every place that it occurs in statute, you have to change that, which makes this bill wordier, longer than it really needs to be. But sometimes people don't want to do those things just because they're a little bit messy and they have to have a big bill. We're doing that in this bill. If the child pornography statute needs to be stackable, we've taken care of that in here to where if someone was already convicted of that type of offense, of child pornography, they would also, if convicted of child sexual abuse material, it would be a second offense. So we've taken care of that to make sure that that doesn't happen. This also creates, since that task force, statewide council, I should say, terminated in December of 2023, this recreates that task force because it's very, very important for the way that we are attacking minor trafficking in the state of Missouri. It's an integral part. It served as an integral part then, and it will serve again as an integral part, but it will be now under the auspices of our Attorney General. Our Attorney General, I think someone may come up and speak for that, but they are eager for this to pass and have been helpful and they were helpful on the previous council, and they have been helpful in moving this forward. This also creates a fund. On page 14, it creates a fund to help deal with that. That fund has been populated with $900,000 already, and it will be $1.1 million. 5 next year populated in that to make sure that we can do the things that we need to do that are created in that council. That money has already went into the fund last year and is coming out of the House with a line item this year. It also connects the CACs that have been created across the state. Someone behind us will speak towards that. Also the juvenile office and the highway patrol and all of and DSS, all of those different entities that deal with minor trafficking in their different, and both in helping the individual that is being trafficked and also the prosecution of the offenders. All of those things need to have a central, integral part, and that part will be played by the Attorney General's task force. There are several different provisions. I'm just going to read through those and try to give you the location in the bill to help you to orient yourself with that. Page 25 deals with hearsay evidence. I believe you heard that in this committee last week on Wednesday with Jeff Coleman's bill. He came to our statewide council, presented to our statewide council at least 2 years ago, maybe 3 years ago now, and we believe that's a great bill. I encourage you to pass that. It is also on here. The restitution piece that he has on his is not in this bill. It's not currently. It defines vulnerable persons for the hearsay portion as well. A vulnerable person is someone who hasn't reached the age of 17 mentally, and there's a definition in statute here, or in this bill, that would go into statute on page 26. Page 28 deals with the statute, and some of those pages may shift depending on where you print, how you had it printed. But the one I'm looking at, page 28, deals with the statute of limitations for sex trafficking and child sexual abuse material offenses, extending them from 10 to 20 years. I know that you have heard from Senator Hudson a bill that changes it from 10 to 20 years, the statute of limitations for sexual abuse. This bill does not include that provision, but it expands those to persons that are sex trafficking or producing pornography, child sexual abuse material as well. This also explicitly on page 38 states that the Attorney General of Missouri can assist in child sexual exploitation cases in Missouri upon request and from a prosecutor or from a circuit attorney. Page 39 deals with the offenses of sex trafficking in the first degree and defines that to be a child under the age of 14 because there's first degree and second degree, and under 14 would be first degree. This deals with the sex trafficking of minor under 17 on page 39 and 40. There also is a part that the Attorney General wanted in there and upgrading the offense of a parent or guardian who is sex trafficking their own child or guardian, and and that's on page 40 if you want to look at that. Page 41, patronizing prostitution of a minor, being a Class E felony, and patronizing a child, a Class B felony. That's on page 41. The rest of the bill contains the language that, is still the 2 words changing to 4 words, child pornography, child sexual abuse material, which I know makes it longer, but is not, it's the same wording everywhere. There were 3 other provisions added on the floor. That, what I explained to you there, was everything that was in the original bill. There were 3 other provisions added on the floor. An ex parte agreement for minors, under people under 17 ages and younger. Representative Jeff Myers' bill, I don't remember the number of his bill, but it had already made it through committee and already made it to the floor when we put that on. In fact, I didn't accept anything that hadn't already been committed and come out of committee with either 0 or 1 vote. I didn't accept anything else onto the bill that had pushback on it. Also, Representative Seitz' bill that has the non-disclosure agreements, which is in section 537.046 and 537.047. Those non-disclosure agreements are in this bill as well. And in section 610.021, the sunshine request for children, so that people can't, if there was a case going on, they can't sunshine request for a minor and then use that to somehow target and perhaps sexually exploit a minor using our sunshine request. And it seems like a pretty common sense piece of legislation. That's 610.021. That was Representative Faulkner's bill, and I also don't remember the number of his bill. But this is a comprehensive effort to go after trafficking, both the perpetrator, the person who's the John who's paying for it, the person who is doing the trafficking, but also it helps. There's several things in here that are working on how to, and I think that's one of the key things for the Attorney General's task force is, and how do we help those children? That was the bill that I presented multiple years ago now. This is my 5th year of doing this. Worked on that side of things, and some of the people that are behind me can explain how some of those things have worked. I think with that, I will open myself up to any questions from the committee.
Representative, I want to thank you for being here today. I know you've had a loss in your family, and I want to offer our condolences from the committee for what you're experiencing right now.
Thank you.
The one question that I have, I'm going to open it up to others, but it's going to be on page 47.
Okay.
Didn't know I had music to go with that, too. That's delightful. Page 47 on lines 29 through 32. Any anatomically correct doll, mannequin, or robot, or any other item with the features of or with features that resemble those of a minor under the age of 18, intended to be used for the purpose of arousing or gratifying sexual desire of any person, or for the purpose of terrorizing or causing emotional distress to any person. Where did that come from? Is that
this came? That was one that I didn't even mention that one. That was a piece that came out of the statewide council, which was brought to us from. There are people that are very perverted out there who will take a doll, put the face of a person, a child, on that, and then video that, and then they can use that as a terrorist technique on that child or that minor, for the purposes of exploiting and terrorizing that child. It's sad that you would even have to put something like that into words, but that was brought to us in the statewide council, and we had testimony about that, and was one of the reasons that became part of this bill.
Any further questions?
Yeah.
Senator Brown.
How you doing, Representative? I saw in here, I just lost it. It changes the statute of limitations. I believe it was to 20 years. Do you know what that is currently, or is it set at when they reach a certain age?
Yes. So currently in statute, if it's at the age of 21, since they're minors, then the statute of limitations. So when that child were to reach 21, they would have 10 years. So they would have, by the age of 31, they would have had to have started the court proceedings. At this would take it from 10 years in addition to make it 20 years. So they would be at the age of 41, which was the original language that was brought to us. We were working also, this one piece of that was Representative Seitz' piece back in 2022, 2023, when that came to us. And so as to not get in his lane, we wanted to apply it to anti-trafficking, for minors that are being trafficked. But we didn't want to do it for just child abuse, because that was his bill, and I didn't want to step on his toes and allow him to do his thing. But obviously, I'm for that as well. So it goes from 31 to 41, if you will.
Okay. Well, I want to thank you for filing this. Looks like you put a tremendous amount of work, and I actually filed Representative Meyer's bill on the Senate side, and this just seems very much more comprehensive.
Several things in Representative Meyer's bill, when we had him come and speak to us. The one piece that wasn't was the training pieces, because there was no consensus. We in our group could not come to a consensus. We had people from the Prosecutor Association, Highway Patrol, the CACs, people behind us, the Attorney General's office, and that was a part that we struggled to find consensus on, and therefore didn't become a recommendation, didn't go into this bill. But I do support Representative Meyer's bill, and a couple of his pieces are in this. The ex parte piece is one of the in particular.
Well, I know it's just a really tragic problem facing our society, and appreciate your efforts to help tackle it.
There's somewhere, from the data that we accumulated, somewhere around 1,000 children a year in the state of Missouri are trafficked, sexually trafficked, somewhere, according to our data, when we finished our conclusions in 2023. So that may be more or less in 2024. I'm not privy to that data being collected, although we have set better ways of accumulating that data now because of what we did in 2023, and hopefully with the Attorney General's Task Force and what we've done with DSS, that will continue to improve as we move forward, so that we can actually know, are we making a difference, or are we not making a difference?
Any further questions? Seeing none. First, in support of House Committee Sub House Bill 1464, please come forward. And all witnesses, make sure you have a witness form.
Good morning. Jessica Seitz. I'm the Executive Director of the Missouri Network Against Child Abuse. We're the State Association of Child Advocacy Centers. This bill has a lot of provisions on it, so I'll touch on a few very briefly, because I've got several folks behind me who can go more into detail, who are attorneys and providers and things like that. But I want to say that we were an original member on this statewide council that produced the report and the recommendations, and we're very pleased to see them included in this legislation. But one of the things that we're really excited that's in here is the renewal and kind of permanent instatement of a task force. What we learned, and even why the council was formed, is that the research around child sex trafficking and adult sex trafficking, for that matter, is always coming out about best practices in services, best practices in investigations. We found that even the different parties, Children's Division and law enforcement, prosecution, weren't collecting consistent data, all of that. And hence bringing the group together, but the group did expire. And so I really encourage, there was a lot of work still to be done. There continues to be, but there's not a place that it lives that, kind of makes people come together. So I encourage you to take a look. It's not just another task force. It was fully staffed, and we barely scratched the surface. So it's been something constantly demanded. So my organization would be happy to sit on that again. And, so I just wanted to highlight that, because again, it's not just another task force, which we've all been there. So then the bulk of this bill is changing parts of the criminal code, so it's so long, but most of the pages make a simple language change from child pornography to child sexual abuse material. Language matters. This is very important. Pornography often implies consent. There is no such thing as consent when it comes to child sexual abuse material. This is also something that is being considered federally, has been introduced several times to amend the federal criminal code. So just throwing that out there. And then the provision in 491 and 492 is similar language, if not the exact same language, to what was heard last week by Representative Jeff Coleman in 615. My organization is very supportive of that language. That's the language pertaining to hearsay admissibility, raising it from protecting kids under 14 to protecting kids under 18. So I was here last week, so I won't speak on that again. And then the other thing that I think is really exciting that we took away was just the recommendation that local prosecutors, just encouraging them to reach out to the Attorney General. These cases are complicated to prosecute. In small areas, you may only have a handful, so who couldn't use another set of hands? So I thought that was another great recommendation that was included. So thank you. I welcome any questions.
Are there any questions? Seeing none. Moving to the next in support of 1464.
Thank you, Chairman, committee members. My name is Pat Kelly. I'm Executive Director of Municipal League Metro St. Louis. Just want to go on record in support of the bill, specifically related to the information that is retained by municipalities and dealing with minors. We have park programs that have lists of minors and participation. We have part-time minors that are working for cities over the summer. And we realized several years ago that all of that information is sunshineable. And we believe it's important to protect that information from people that would use it in the wrong ways. We've been working on this legislation for several years. It was in a bill 3 years ago that was passed through the House and the Senate, part of a much larger bill that then got vetoed by the governor. But we continue to work because we feel that this is very important to protect that information that the cities hold dealing with the minors. I'd be happy to answer any questions.
Any questions? Seeing none.
Thank you.
Next in support, 1464.
Mr. Chairman and members of the committee, Darrell Moore from the Missouri Association of Prosecuting Attorneys and the Missouri Office of Prosecution Services. We certainly appreciate Representative Lewis and his dedication to protecting our children. As some of you may know, I was a Greene County prosecutor as assistant or elected for 28 years and handled child sex cases, and it's unfortunate the sheer volume. In fact, during my term as the elected, I had one whole section dedicated solely to dealing with the crimes described in this bill. This bill improves that process. In particular, I just want to focus, certainly support the entire bill, including the trafficking section, but in particular the 491 and 492 sections I testified on last week. I just want to make it abundantly clear that's been the law for years, and the Supreme Court of Missouri has repeatedly upheld those sections as complying with the due process and confrontation clauses of the United States and state constitutions, so there's no issue there. I've used it in numerous cases through the years, and all we're asking here is that it be extended to 17-year-olds and younger, not just 14-year-old. It's a very useful tool, and I would point out the child is still made available for trial to be subject to cross-examination if the defense wants, and the child is still subject to deposition by the defense if they want to depose the child before trial. The other piece that is important is the 491-641. The witness protection language currently only allows a law enforcement agency to apply for the funds. This would extend it to prosecutors' offices. We've tried to do a workaround the last few years, which is kind of convoluted, where we've tried to work with local law enforcement to engage in a process where they can apply for the funds for us. This just makes it simpler where the prosecuting attorney or the circuit attorney could apply for the funds. And finally, I would say, sometimes the prosecutors have been known to raise objections to the Attorney General having anything that might appear to encroach upon original jurisdiction. We have no issue with that. The clause that she spoke of last that encourages prosecutors to use the Attorney General, we have continued to do that. Under current law, prosecutors can ask the governor to appoint the Attorney General to assist. When I was Deputy Attorney General for the Criminal Division under Attorney General Hawley, we entered into an agreement with prosecutors that we would try to split those duties. And in fact, in the Missouri Office of Prosecution Services, we also have a child resource prosecutor that can try these cases. Since I've been executive director, I've tried one of these cases. So the Attorney General has worked with us well, and the reality is, as she says, that many prosecutors do not have the staff or training or experience to handle these cases. So we certainly do want to encourage them to use the Attorney General. I would be glad to answer any questions.
I've got one question in regards to the, not necessarily the changing of the term pornography to the sexual abuse material, but do you believe that there are enough provisions in here that can adequately prosecute individuals that are using AI to create some of these graphic images that may look real? And I thought about that doll statement on page, I think it was 71 or 47. But do you know if there's any sections in law that we could utilize currently, or should we amend the laws that we have to address these changes with AI?
Well, Senator, you raise a good question that we're struggling with right now. In fact, at our spring conference next week, we're having a session on AI and how it... So I would say to you that we're making the best use of the law that we can now, and we're probably not in a position to intelligently discuss with you all how the law needs to be changed. I think we're going to have to spend more time and dedication. I know that nationally there are efforts to look at that issue. Mm-hmm. I'll be honest with you, you see my gray hair. It's still kind of hard for me to wrap my head around AI, and part of me is glad that I'm leaving and retiring so that I don't have to deal with it. But to answer your question, you raise a great issue, Senator, that we're going to have to look at over the next 2 or 3 years.
Okay. Any further questions? Seeing none. Next, in support of 1464. And just by show of hands, how many more witnesses are here? Perfect. Please proceed.
Good morning, Julie Seymour, Executive Director of the Child Advocacy Center of Northeast Missouri, which is located in Wentzville. We serve 14 counties on the northeastern part of the state. So we are one of the CACs. We were the first in the state to get a CSEC coordinator. That's the Commercial Sexual Exploitation of Children. We were lucky enough to get a grant to fund that position, and then we were asked to sit on the council with Representative Lewis, and we were very honored to be able to do that. With that CSEC coordinator, we have expanded our services. We have great connections now with the National Center for Missing and Exploited Children, FBI, other agencies and partners out in the community. So we've taken it more from just looking at the kids when they're coming in and giving forensic interviews. And on average, our forensic interviews, we do over 1,000 a year. And there's a 21% of those cases that come in that have a trafficking or exploitation component to it. We know that that case is really higher because we are missing it. Those partners that are investigating those cases are missing it. And a huge part of what our CSEC coordinator does and what this council is going to be charged with doing is training those individuals that are actually doing these investigations so that we're not missing those kids that are being trafficked and exploited. So I'm here we support all of the provisions of this bill, but first and foremost, I wanted to support putting that council back together, making it a permanent council. This topic, this tragic thing that is happening in our society is changing every day. It is hard for us to stay up on the methods that abusers are using. AI is just one component. All of the methods, gaming systems, all the things online, the way kids are able to be victimized and how they're approached, just through Xbox, through Snapchat, all the things that kids are using on a daily basis. And we do training out in the community, and we've learned, we used to do internet safety with fifth graders, and we've learned that we were way behind. As low as third grade, these kids are well versed in all things internet and on phones and how to hide all of the things, so parents that are being diligent and looking for these things, they're able to hide it. So this task force will help put some of those structures in place to help educate and support those that are investigating it as well as the victims. The second provision that I wanted to testify to was the 491 and the 492, and that's that hearsay. Right now, the day you turn 14, you would no longer be allowed to have that recorded interview submitted into evidence. Nothing changes the day you turn 14 from the day before when you were 13. And what's really sad about that is sometimes we have these cases come in and we have forensic interviews that can come in and testify as expert witnesses. And if that DVD, that recording is never submitted into evidence, our experts cannot come in and talk about the dynamics of child abuse, the process of disclosure. A lot of questions come up, well, why did the victim keep going back if this was really happening? Why are they laughing when we're trying to have this hearing? Those are all dynamics of child abuse, and our experts could come in and testify to that. So there's lots of things and lots of reasons, and I'll just tell you another one. We had a case that is currently it's in the appellate court. The victim at the time of the offense was 13 years and 7 or 8 months old. So her recorded interview was allowed into evidence, and it's now going through the appellate court. Had she been just a few months older, that testimony would never have been able to be admitted. So you're not seeing the person at the time, how old they are, what their cognitive ability is. That person is now a 23-year-old registered nurse. So she's going through the court system again. And if her recording was not admitted, the judge and the jury would see a 23-year-old young professional, not a victim of the abuse. So we're very much in support of that 491 and 492.
Thank you for your testimony today. Are there any questions? Seeing none. Next, in support of 1464.
Good morning, Mr. Chairman, members of the committee. My name is Richard Sheets. I'm the Executive Director of the Missouri Municipal League, and we would like to go in support of House Bill 1464, specifically on the section in the Open Meetings Law, Section 61021, that allows municipalities to close records of minors. Because that's really a loophole right now. This bill fits very well. That section was originally proposed in House Bill 145 of Representative Faulkner, but it fits extremely well in this provision because it's kind of a backdoor way for predators to access personal information of minors. And it's, I think, something that really was overlooked, and this corrects that information. And I'll answer any questions if I can.
Any questions? Seeing none.
Thank you.
Next, in support.
Good morning. My name is Julie Miranda, and I'm the Executive Director of Magnolia, which works in Central Missouri with survivors of trafficking and exploitation, and we are also certified to provide curriculum to K through 12th grade about trafficking and exploitation. I'm also here on behalf of the Missouri Coalition Against Trafficking and Exploitation, since their Executive Director is on maternity leave and could not make it here. But I'm here to speak in support of this bill. Specifically in the part about changing the language of child pornography to child sexual abuse material. I've been in the anti-trafficking field for about 10 years now, and we've really learned the importance of language when speaking with survivors and advocates. A large portion of pornography is considered legal, and so whenever you have a phrase like child pornography that equates explicit images of a child to something that is legal, it really diminishes the abuse that the child has gone through. Approximately 50% of trafficking survivors have had pornography made of them while they were being trafficked, and a lot of those survivors entered into the world of the sex trade between 12 and 14 years old. And so a lot of these adult survivors that we're working with now were once trafficked children, and we're seeing that carry on throughout the rest of their life. They're having to deal with these images that were made of them as children, now as adults, and they're worried about resurfacing. Maybe they've come out of trafficking, maybe they're trying to work a a legitimate job, things like that, but they are worried about these images resurfacing and continuing to just cause chaos and trauma throughout the other parts of their life. So for those reasons and many others, I am in support of this bill. If there's any questions, I'm happy to answer them.
Any questions? Seeing none.
Thank you.
Thank you. Next, in support of 1464. Seeing none. Any in opposition of 1464? I think this might be a first. A bill that's this big and this impactful with no opposition. Any for informational purposes? Seeing none. Representative, any closing remarks?
Yeah, thank you for hearing this. I think all the provisions that I have in this bill have been vetted pretty well. There are, two little clerical things that are going to have to be tweaked that were introduced truly by by clerical errors on the House side. So we'll have to deal with those. But I appreciate you hearing this. This is not a bill in any opposition to Jeff Coleman's bill. His provisions on hearsay are super important, need to be passed, whether it be in this bill or in his bill or in both bills. We need to make sure that those coordinate together, that we don't have a conflict in any way. But we need to get this done. We can't wait another year for some of these provisions to go into place. I appreciate you guys hearing this testimony, and with that, I close. Thank you.
Thank you, Representative. We will be voting this out next week, just so you know.
All right, thank
and that will conclude the public hearing on 1464. Now moving to I think we saved the best for last, Senator Carter. Senate Bill 809.
Mr. Chairman, for the record, Senator Jill Carter representing the southwest portion of the state in the 32nd District. I'm out of breath. Running up and down the stairs is good exercise. Senate Bill 809 is in relation to juvenile detention facilities. I'm out of breath. Under current law, circuit judges have the authority to establish juvenile detention facilities for counties within their judicial circuits. Senate Bill 809 builds on this by empowering county commissioners or governing bodies to take a more active role. I ran behind a guy. I was running up the stairs, and he was almost 80, and I was still out of breath. So there you go. I told him I didn't have the excuse. I was glad he slowed down. Basically, I'm just going to tell you the situation in our district is first-class counties have the flexibility and the ability to put a sales tax levy for judicial centers. For those counties who are not first-class counties, they're having to ship their kids clear across the state, which means that, at least in my district, we're having our kids go to St. Louis, Camdenton, which means that parents and those families and those community members who have ties to that child no longer have the ability to really visit with them or help them when in that critical time. So what we're trying to do is be able to bring this bill will give them the flexibility for the commissioners in those counties to be able to collaborate together to pass a sales tax that would allow them to build a facility and a resource center that's collaborative amongst the counties. So I think Senator Black had a similar bill in relation to jails. And this is just that almost identical language. It just is for judicial centers. Again, we're, at least in my district, and those counties that are not first-class counties are having a hard time finding beds for the kids. There are times where I've met with the commissioners, the judges, and our law enforcement and our judicial officers who are saying that they are having to pick between whether or not to have those kids placed in the facility or just not even have them placed, because even though they need to be placed somewhere, because of the shortage of beds, they're not able to. And so the judge, instead of being able to put them and get them the help that they need, or to be able to, when they committed a crime, they're having to just let them go because there's nowhere for them to go. So anyway, this bill would help remedy that and put it back kind of in the hands of those counties that are not first-class counties to be able to work together to build a judicial center. So with that, any questions, I'd be happy to answer.
Senator Berger.
Would this, thank you for bringing this forward. This is a big problem for us too. Would this be limited to circuits? Or would this be, how would the districts, would it be sales tax based? Would it be personal property tax based, or how would it be based?
No, it would be sales tax based. And we were trying to figure out how to, because this is a new classification, we worked with the judges to figure out who would preside over that. We figured the circuit clerks, circuit judges would be the best ones to kind of oversee that program. And so it is based on the circuit judges.
So
the districts.
So like we share a district with Miss Scott, Mississippi County as a circuit.
Yes, so those circuits could work and collaborate together to build a judicial center.
But you couldn't be outside of circuits. You couldn't have two circuits for one facility, or do you know that?
Well, if your circuit includes the two counties or whatever it is, yes, you could collaborate together. Oh. So like in my area, there's no way that one county is a class 1 county. They have a judicial center or a detention center, but only has 8 beds. So there's not enough to accommodate nobody else in that region. One of my other counties is not a class 1 county, and they have nowhere for their kids to go. So we have this disparity between these counties. What we're trying to do is break it up into a circuit so where there's someone overseeing that, but the commissioners can collaborate. They can go in together on passing a sales tax to be able to accommodate those resources across county lines.
Well, when I think about this, Scott, Mississippi County is a circuit. Then south of us, there's 3 counties that are a circuit. Could those 2 circuits go together?
I believe that they can. That was part of the goal. So let me verify that. But the intent was for them to be able to collaborate. So
because that would be good if the circuits could go together, because I don't think we could support it in Scott, Mississippi County, but if we could pick up New Madrid, the county south of us, Mississippi, I think that's something that we would go after.
Yeah, the cost and staffing and everything else
Right.
is just making it out of reach, puts it out of reach of a lot of these other counties. So especially their rural areas, they're really having a hard time being able to take care of the needs of their communities. This will help them be able to share resources to be able to do it.
Let me know about the circuits
Okay,
for sure.
I
Thank
sure
you.
will, thanks.
Any further questions? Seeing none. First in support of Senate Bill 809. Seeing none. Any in opposition of Senate Bill 809? Seeing none. Informational purposes.
Senator, I'd be happy to submit letters or testimony or whatever of the counties who, like I said, this has been a labor of love for my area and a lot of the other areas as they've talked to other counties. And so this, I would be happy to have them write testimony in favor of it. But, and there is some. So anyway, if we need more testimony, happy to provide that.
Mr. Chair, members of the committee, Eric Jennings again on behalf of the Judicial Conference. The underlying issue that Senator Carter is attempting to address is one that we've grappled with. If you haven't served on the appropriations of the Budget Committee, we've had several new decision items each year for the last several budget years dealing with secure juvenile detention centers and some of the pressures that they're facing. I know at least both actually, of the sections originated in 1957. One was amended in 1998, and so there may be some updated terminology that we would suggest for this to make sure that everything is clear on how it operates and matches what current practice is, current statute.
Any questions? Seeing none. Any others for informational purposes? Seeing none. That will conclude the public hearing on Senate Bill 809. Having nothing further before the committee, I now make a motion that we adjourn. Do we have a second? Having a second, we are adjourned.